Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an employee confesses to committing misconduct but later disputes the confession. What are the applicable legal principles? This was decided by the Labour Appeal Court in its first judgment for 2024 in the matter of Brawns and others versus Wilkes N.O. and others. Briefly, Mr. Brawns, the first appellant, was employed by the South African Police Services as a financial clerk. It was alleged that he misrepresented that he and the other two appellants, being his wife and sister-in-law, were entitled to overtime payments, knowing that they were not entitled to such payments. In turn, the second and third appellants were alleged to have defrauded and prejudiced the state by not revealing or informing the SAPS that they had received the overtime amounts which were not due to them. All three were charged with fraud and with conspiring with each other to defraud the SAPS. They were all found guilty and were subsequently dismissed by the SAPS in July 2016. An attempt at overturning their dismissal through the internal appeal process was made by the former employees. However, the same was unsuccessful. Accordingly, an unfair dismissal dispute was filed with the Safety and Security Sectoral Bargaining Council. This referral too was unsuccessful, as the Commissioner found their dismissals to be both substantively and procedurally fair. Totally aggrieved by the results so far, the former employees lodged a review application at the Labour Court. Once again, the case was dismissed, and accordingly the appellants appealed to the Labour Appeal Court. It was common cause that the appellants received the unauthorised payments, that they did not work the overtime for which they were paid. The payments were made using other employees' access credentials to the SAPS payment system without these employees' knowledge. It was also common cause that the first appellant made a confession about his fraudulent conduct before a magistrate. In the appeal court, the appellants contended that the Commissioner's reliance on the confession of the first appellant was misplaced because at the time it was made, the first appellant was emotionally threatened with criminal prosecution and operated under the oblique notion that he was ostensibly liable on account of his user ID having been used in the transactions. It was further argued that the confession was made before the first appellant managed to consider the evidence, especially the fact that he was not at work when the transactions were performed. The appeal court held that an essential element in labour disciplinary proceedings is that a confession is an acknowledgement on the part of an employee of a fault, wrongdoing, or breach of a rule. It is right that an employee may be found guilty of misconduct upon proof on the balance of probabilities in labour matters. In other words, an employer has the onus to prove that the confession was made and is valid. A confession is said to be valid if it is freely and voluntarily made without undue influence, coercion, or intimidation from the employer or any other person. The court held further that the other requirement for a valid confession is that the employer must show that the confession was clear and unambiguous, and that the employee understood the consequences of the confession. A confession does not amount to a plea of guilty on the part of the employee, and thus the employer is still, even in the face of a valid confession, required to follow a fair procedure and determine if there still exists a substantive reason to terminate the employment relationship. In other words, the employer must show that the dismissal was an appropriate sanction in the circumstances of the case. The question of whether a confession may be rendered invalid based on fear of criminal prosecution depends on the circumstances of each case. A confession in these circumstances may be considered involuntary or influenced by a promise or threat, and therefore inadmissible or unreliable. But this will not be the case where a confession is made willingly and corroborated. In the present matter, the appellant voluntarily and freely made a confession before a magistrate. One of the other arguments made by the appellants was that Mr. Braun's confession was rendered invalid because it was made before he had information relating to the disciplinary charges and had managed to consider the evidence. The appeal court found this argument to have no merit. The charges of misconduct against the first appellant were based on the evidence gathered by the SAPS, including the confession. A confession generally forms part of the investigation into an employee's misconduct. It is not made by first finding out what information the employer has. While a confession can inform the charges preferred against an employee, it is not the only factor determining the outcome of the disciplinary proceedings. An employee who has confessed to an offense could still challenge the confession itself, including its reliability at the disciplinary hearing, or present evidence and argument to prove their innocence or to mitigate the severity of the sanction. The court concluded that the employment relationship imposes an obligation on employees to act honestly and in good faith, safeguarding the interests of the employer. The high premium placed on honesty in the workplace has led our courts repeatedly to find that the presence of dishonesty makes restoration of trust, which is at the core of the employment relationship, unlikely. Dismissals for dishonest conduct has been found to be fair where continued employment is intolerable, and dismissal is a sensible operational response to risk management. The appeal was accordingly dismissed. It is important to take note of the key takeaways of this matter. Firstly, employers must prove that a confession was freely and voluntarily made without coercion or intimidation, and the employee clearly understood its consequences. A confession alone cannot justify dismissal. Employers must follow a fair procedure and determine if there is a substantive reason for termination. Whether a confession is valid if made in fear of criminal prosecution depends on the circumstances. It may be considered involuntary if influenced by a promise or threat. And lastly, an employee's confession can inform charges, but it does not render the confession invalid if made before knowing the charges. Confessions are part of the investigation. This case, colleagues, emphasizes the importance of fairness in the employment law, even when dealing with confessions, to ensure just outcomes in disciplinary matters. That brings us to an end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.